here, if there's anybody that is in the audience that would like to speak, we have a moment for a hearing session.
There were no requests to speak for today.
Thank you. And now we'll be moving on to board operations. I'm going to turn this over to Mrs. Lundeen to conduct the meeting from here on out.
Thank you, Mrs. Lieber. At a special meeting of the board on Saturday, January 16th, the board voted to approve separate legal counsel to represent the board for pending litigation. Today's meeting has been called to approve a contract with the firm of Mundell, Odlum, and Hawes for its legal services. Do I have a motion to approve?
I have a lot of questions before maybe we get there.
Wouldn't we have the motion, second the motion, and then have a discussion? Isn't that the procedure? Or am I wrong on that?
No, that's correct.
That would be appropriate. You would get a motion, a second, and then you can open it for discussion.
Perfect. Perfect.
Okay. So back to my question. Do I have a motion to approve?
I'll motion that. I'll motion.
Do I have a second? I'll second. Discussion. Mrs. Weaver, you had questions?
No, Joanne, Mrs. Lopez had questions.
Joanne.
It's
Sorry,
okay.
Mrs. Lopez. We can't see you, sorry.
I know, sorry. Not very much tech savvy. So I guess my first question is, how is it that we arrived at having Mr. Moore or any prospective attorney already here for approval? It seems like there would be a process of where we would have looked at several attorneys and discussed it and looked at their contracts and looked at their fees and looked at a lot of different things. So how did we arrive at Mr. Moore?
That's a superb question, and I really should have addressed that at the top. We actually tried to move quickly, understanding that time was important in this situation. And at the last meeting, if you recall, Mrs. Lieber and I were given the opportunity to identify legal counsel. We've actually interviewed 3 separate firms extensively. And we were looking for experience in education law in the specific issues that the board is going to be looking at in this situation. And Mr. Favela and I have had extensive conversations with Mr. Moore and felt that his law firm's expertise and area of expertise and the clients he has served and the issues that he has worked with served us exactly correctly. And all the fees were fairly similar. So it turns out fees weren't that much of an issue. I don't know, Mr. Favela, if you'd like to add any more. I know you had a long discussion with him as well.
Sure, yeah, I had a chance to speak with Mr. Moore. And I felt that, you know, what he was presenting was what is helpful for this moment. You know, my questions are just, you know, just to make sure we know our rights as board members, and to make sure we're looking for, you know, a fair and balanced approach, and really looking for a means to move our board forward together. Really looking for ways to precisely that. You know, we want to, you know, I'm looking for a process that will help our board move forward together and resolve whatever needs to be resolved in a way that will ultimately be productive. So this is a recommendation. This is, you know, I only had a chance to speak with Mr. Moore, as a matter of fact. So from the initial discussion that I had, I think it was worth presenting to this board, and it's a recommendation. So my experience in education and being a leader in a very large high school is that school boards don't typically hire people. It's typically the district office that does that. So when we had our meeting, we did agree to outside counsel that there was a necessity to have
outside counsel, maybe, but it shouldn't be somebody from the board that would have initiated that. It should have gone to the district office for them to then review a variety of people and come back to us with some recommendations. So I'm curious, how did we do it backwards?
I wonder if it would be appropriate to ask Mr. Moore to respond to some of these questions. I think you probably have the breadth of experience to respond to the specific questions that Mrs. Lopez is presenting.
Only if Ms. Lopez wants to hear from me. If she's directing her questions to board members because that's the preference, then I think it's appropriate for board members to answer it. However, if Ms. Lopez is willing to accept a little input on my end, I'm happy to provide it. Is that okay, Ms. Lopez?
Yeah, it'd be great, because then I do have several questions directly for you.
Okay, well, very good. I hope I'm able to answer them for you. First of all, I understood that the scope of representation needed at this particular juncture was fairly narrow. And the reason it was narrow is because there are concerns that if there's a complaint and both parties involved are at different levels of the governance, you have one at a governance level and maybe one at an administrative level, that having an investigation done in-house makes it very difficult for the one performing that investigation, specifically if it's HR or some other department, to do so in a way that both parties will be comfortable with the outcome. And so with that in mind, that concern flows also to staff members who may be making that decision privately. I agree with you. I have seen it done in a number of ways. For instance, in a lot of instances, you have a board member who may come up, whether it's a legal contract or some other contract, who lets the superintendent or another staff member know, you know, I've become aware of this particular vendor. Would you look into it? And in those circumstances, they look into it and they say, okay, yeah, we'll be happy to put that on the agenda. The other way that I've seen it done is in a situation like this, where there is an issue which calls into question whether or not the board can act on a particular item while doing so objectively. And where that's the case, I have seen boards bring on counsel for a very narrow purpose, which is carried out by that individual. And then a report is generated, and the report doesn't just go to the board, it goes to anyone who's involved in the issue. So in short, it can be done a number of ways. I agree with you. I've seen it done the way you described, but I've also seen it done in this fashion when in fact a particular need of the board, for instance, an investigation, is necessary that implicates a member of the board or a member of the administration in a way that both parties or all parties can trust that there's an independent decision. I hope that comes close to answering a part of that question.
Yes, it did. Thank you. So based on part of the answer that you just gave, and based on the email that came out this morning from Mrs. Lundeen, I would respectfully ask that Mrs. Lever leave this meeting, both this meeting and the closed session meeting, and recuse herself to avoid any conflict of interest that she might have based on the issues that we may discuss, because it potentially has implications for her directly. And for us to make a decision that could in fact impact her by hiring you, that bothers me.
Is that directed to me, Ms. Lopez?
Actually, it's directed to the board.
I'd like to respond, at least with my perspective. I think all of us have an opportunity to provide theirs as well. When we had this discussion on Saturday, we accepted input from every member of the board. And on Saturday, we had a vote, and every member of the board participated in that vote. Of all our votes, that would be the most consequential. That is the one that determined whether or not the board would hire lead counsel. So that was the point at which, if someone were really concerned about impartiality, that issue should have been raised. And that's how that vote should have been conducted.
It was raised.
Given that
I specifically raised it. I specifically raised a conflict of interest at that time.
But you didn't have support within the board
Well,
for that position.
I would like to state that I also have concerns about conflict of interest. And I know that my fellow board members, we all care very much about transparency and making sure that any actions we take as a board are, completely above board and transparent. And so I would like to second Mrs. Lopez's request that Mrs. Lieber recuse herself from these discussions in this vote.
Okay, then we can, if I'm correct on Robert's rules, we can table the first motion and hear the second motion. Is that correct? Okay, so I make a motion to table the first motion and hear the second motion just presented by Mrs. Lopez and seconded by Mrs. Leaves. Do I have a second for tabling the first motion?
I'll second.
Okay, all in favor?
Aye.
Aye.
All opposed? I'm gonna abstain.
So we have a 2-2
So-
vote. I've lost the voice for Karen and Favela.
I'll abstain.
Can't hear you.
Okay, we can hear Ricardo, but not.
Okay. So you're going to abstain and Suzanne's going to abstain. So I voted no, so it's a 2-1.
So we will hear your request. We will hear the motion. We can discuss it and then we will vote on it.
Mhm.
Is there anything that Mrs. Leaves would like to add or Mrs. Lopez would like to add?
The only thing I would like to add is that there's not only a concern of maybe facts, but it's the concern of appearance as well. And we have to be very careful of how we appear to the community and the public. And we have a board member who, has a complaint. Actually, we have a board that has a complaint against them that could potentially have impact on one specific person. And to me, that if we're hiring someone to represent this board, but also potentially representing Mrs. Lieber, that's a clear conflict of interest for her to have impact on who and where we hire somebody.
Can I speak here? Joanne, I think you got it a little mixed up. We don't have, I think what your understanding is of what the litigation is about is not exactly correct. We have an employee of the district making the accusation against a member of the board. So I just want to clarify that. It's the board, it's not the board accusing someone on the board. It's a member of.
Of course, I know that, but you're the person being accused. So for you to be involved in the decision-making process of who we may hire to protect all of us is a conflict of interest, in my opinion.
Okay.
And maybe Mr. Moore has an opinion about the conflict of interest issue. I don't know.
I'd be happy to address it if we can.
I think I need to remind everyone we are in open session. I think I need to just remind us all we are in open session. So please frame your comments recognizing that we are in open session.
Well,
Mr.
I would just like to return to the point, the point of this conversation, which was to ask Mrs. Lieber to recuse herself, which she can choose to do on her own. I was so it was done on a planning group meeting the other night. Board member who felt that there was an appearance of a conflict of interest and recused himself from the discussion and the vote. So
Thank you. I think Mr. Moore wanted to say something.
Only for your consideration. Certainly, at this point, I don't represent the board or anyone on the board. I'm just here at your will and pleasure, and I appreciate that. Certainly, I think the concerns of making sure that someone who has an inside involvement in something which is being looked into should not vote on the subject. I think, Ms. Lopez, your points, at least with me, are well taken, and I don't have an issue with that. But I'm in an interesting position because I've been invited as a guest today, but not employed, and so I want to be very careful with that. But from my personal perspective and my experience, your aim in this is well founded, and whichever way the board decides to go, whether it's my firm or somebody else, whomever it is, I think that your point is well taken, at least from me.
Thank you.
Well, I suppose I'd like to speak on the other side of this. When we voted to approve council, we voted as a board because the board itself had no access to legal information as an independent source of legal information. And we also talked at that board meeting about not the perception, but the fact that the board president represented the board in her implementation of her responsibilities in that capacity. So that was, in fact, sort of the response that we made on Saturday. And 3 members of the board agreed. I abstained from the previous motion because I wanted to have us have the opportunity to discuss this. But let me be clear, I'm very clear on my position. And my position is that on Saturday, we took a vote, and that vote holds. The vote was to hire legal counsel. This is not the time to chip away at that vote. The vote occurred, legal counsel is going to be hired. The board has the right on its own, not through staff, on its own, to hire legal counsel and direct legal counsel. And that's what we are looking for in this instance. So under no circumstances would I support having district staff hire counsel in this case. They've already hired who they think should be counsel. Some of us don't think it's impartial. So with that said,
I think you need to be
no one
very
else-
careful in saying that you know that legal counsel will be hired, because you don't know how the vote is going to go.
No, we did take that vote, Mrs. Lopez.
We took
The
the vote
vote
to
that we
hire legal
approved-
counsel. You're right. We took the vote on Saturday to hire legal counsel, and we took a vote so that we would look at that. And that's part of the
No,
process
we took
today.
a vote. The actual language that we approved is we have voted to approve separate legal counsel to represent the board for pending litigation. Not that we might hire them, not that we ask somebody else to hire them, but that the board will hire separate legal counsel to represent the board with pending litigation. Those are the exact words.
right, but the fact now we have to vote on which counsel to hire is where we're at now, and that is still yet to be determined. I personally have concerns about Brown Act violations in this regarding this action item because of statements that were made after our last board meeting on Monday. Once the meeting was adjourned and the public left the room, there was a statement that Ms. Lundeen made regarding this this contract. And so I'm, again, very concerned about conflict of interest and transparency. And I think we need to be very careful how we proceed in this process because it is not the way that contracts traditionally would be developed and processed in our district. Normally, it would be staff that would help in this process. So we voted to, the majority of the board did vote to hire legal counsel, but you know, there is a question of how that, we did not specify how that process was going to occur. And I think Ms. Lopez and I were both surprised to see this contract come before us so quickly when we, you know, had heard nothing else since that vote. And then suddenly here we have a contract with a rate and very little information about how it came to be.
I think those are fair questions, Mrs. Leaves. I do. And we'd be happy to talk about the process because those are fair questions. And if the board would like to know more, we moved quickly because we know that there's a 60-day timeline on this. And we wanted to be sensitive to that. Believe me, I was not happy about having to work on Monday, which we were back-to-back interviews on Monday. And there have been more this week. So you're right. The due diligence that we went through, we should share so that you can have confidence that this was a process that we were trying very hard to bring forth a firm that would see the whole picture, the picture of the district as a whole with the staff, with the board, and could be impartial across all of those lines. Because the reality is we are one unit, one organization. We may have different roles in the organization. Our role is governance and vision and oversight. The district's role is the actual implementation. But we are the Fallbrook School District. So we were not looking to try and bias the process by who we would select. We were actually trying very hard to get someone who could see the whole picture. And one of the things that impressed me, for example, about Mr. Moore is that he was very clear with me in that his perspective is the whole picture. And he wanted to be sure we were okay with that. And, you know, I thought that was right and fair, and that's where we come from. I don't know, Mr. Favela, if you want to add to this discussion. I don't want to put you on the spot, but I know that you participated in at least this interview, and I'm sure have given some of this some thought.
Right, yeah, just in the interest of moving forward as quickly as possible to help resolve this overall. You know, I thought it was worth inviting Mr. Moore to be considered. You know, this is an overwhelming process. You know, stepping into this, you know, I greatly value, you know, second opinion on these issues, so that we can make sure that we make the best or have the best outcome overall.
So I have some specific questions. So who has actually spoken to Mr. Moore before this meeting?
I did speak to him.
Mr.
Yes.
Favela and Ms. Lundeen? And Mrs. Lieber, did you also have a conversation with Mr. Moore?
I've talked to Mr. Moore.
Okay.
So we have a problem right there that 3 board members have had contact with somebody outside the board about for informational purposes. That's a violation of the Brown Act right there.
We did not confer.
It doesn't matter. You had a conversation with him all on the same topic. You 3 didn't have to confer.
We didn't actually have a conversation with him on the same topic. Mr. Favela and I had a conversation with him on the topic. And Mrs. Lundeen called him just to get him organized for this, checking into this meeting. So it was not on the same topic. She was going to run this meeting. Mr. Favela and I did the interview, and all she did was set him up to be prepared to come join us, and that he had the time.
Well, I mean, just the fact that the three of you are coordinating that is, in my understanding, a Brown Act violation. My other concern is the information that you communicated with Mr. Moore. My understanding is that it's confidential, and that since he's not under contract with the district, should not have been privy to the details of the situation that we're facing here. Mr. Moore, can you describe the nature of the conversations that you had, considering that you did not have an attorney-client relationship with their district yet?
Sure, I'd be happy to. The nature of the conversation that I had with Mr. Favela and Ms. Lieber revolved around the need for counsel to perform a particular task. The specific details of the matter were not shared with me. It was a question that revolved around my availability and the skill set that our firm usually brings to the matter. So I'm not privy to any of the facts of the matter, only that there was a need and an interest to determine whether or not my firm and my services might be useful. With regard to the communication I had with Ms. Lundeen, it was for the purpose of making sure I knew how to get on this meeting. And so that was the focus of it. I'm here at the board's pleasure. And if at any time the board needs to have another conversation without me present, I would certainly invite you to do that. I don't represent any board member or this district. And so as a result, I wouldn't have allowed and would not allow a consultation with regard to the specific matter at issue. And I would encourage this board, from my personal perspective, if there's any question about whether or not you want other counsel, I would certainly suggest that you vet as many counsel as necessary. And if for whatever reason there are particular bylaws that you have that outline the responsibility for bringing third-party service providers before the board, that you certainly adhere to those. I have not had the opportunity to review your board bylaws. As I sit here today, I have very, very little information and am here solely by way of invitation. So if you decide that any member of the board would like further information, my experience has been it's not infrequent for something to be put on an agenda and for board members to ask for the matter to be tabled so that they can gather more information. That's typical and good. But in terms of something that I would be involved in that would violate the Brown Act, my experience has been that I do my very best to steer that away. The calls I received were simply to check on my availability and whether I had the requisite experience to assist a school district, frankly, on any level. And any doubts over that, certainly I would invite anybody to compare and talk to as many other service providers as you would like.
Mr. Moore, can I ask you, who did first contact you and when was that?
Let me see. I believe the first contact for this, correct me if I'm wrong, let me look at my calendar. I think it may have been Monday, I think, for a few minutes. And the contact that was made was from Ms. Lieber and Mr. Favela, who reached out to me for the purpose that I just described, which was to check on our bandwidth, so to speak, and whether or not we had the requisite experience to assist boards with a variety of things. But we didn't have an extensive conversation. And I certainly don't know any of the details of the matter or matters. I don't even know if there's more than one or however many you may have at that time. And then my conversation with Ms. Lundeen was equally brief. That was today. shortly before this meeting to make sure that I could access the meeting.
So you have not been provided with any kind of documents prior to this meeting related to anything in our district?
I have no documents. I've not seen any documents. No documents have been offered to me that I can check. I mean, I can go through my emails right now, but I haven't been able to review anything, and no documents have been offered to me.
I have a question, and I'm not sure who the best person is to answer it, but on our agenda today on this item, we have two supporting documents. One is a draft of the legal services agreement that has a signature line for Mrs. Lieber, and then there's a revised draft with a signature line for Ms. Lundeen, and that was emailed this morning. So I'm wondering why that change was made.
I can comment to that if you don't mind. Because we haven't had anything extensive and Mr. Moore knew that I was the board president, he just assumed that it would be sent to me. And then when Mrs. Lundeen saw it, she thought it would be better if it was sent to her. That was the only reason.
Okay. So, Mr. Moore, do you have a concern that any of our individual board members have a conflict of interest in this case?
Well, as I said a little bit earlier, my personal perspective on this particular issue, and please, I'm at a little bit of a disadvantage because I don't know all of the people who might be involved in the matter that I might be called upon to look into. If any particular board member were part of the matter that needed to be investigated, I would certainly expect that board member not to vote on an investigation or a task that might implicate them. So that's not necessarily an issue. And certainly I haven't been involved with your district, but based on what I've heard described, what it sounds like is at some point in the recent past, a vote was taken to obtain separate, narrow focused counsel, and that the purpose of some subsequent meeting, which this may or may not turn out to be, was for the purpose of employing that counsel, and if it wasn't that, for at least determining next steps. And so with that in mind, if, for instance, I've been practicing employment law both on the civil side and the governmental side for a long time, if there was an accusation or a question or something that implicated an employee and an employer at any level, those two individuals would participate in whatever the investigation was, but they would not participate in decision-making processes that would arise out of that investigation. That would be a blatant conflict of interest. And so I don't have enough facts here, but I can't imagine that outcome was contemplated or implicated. Certainly, I wouldn't engage if those were the parameters. But again, and I'm sorry, but I'm operating with a dearth of information, and I hope I'm able to answer your questions based on the little I have been given.
And I would make the argument that we're not talking about someone in the decision-making context of the merits of the case or the case itself. We're merely talking about counsel to represent. So I think we've had discussion. I'd like to call for a vote.
I have some additional questions actually for Mr. Moore. So you were talking about the implications as far as like the outcome of an investigation, but regarding Government Code 1090, which states that if a party has interest in a contract that that creates a conflict of violation or a conflict of interest. So if an individual board member was going to vote on a contract and Government Code 1090 prohibits board members from entering into contracts in which they have an interest, do you think that that would be a conflict of interest?
Well, I think it's important to define, and it's not well stated in 1090, But the general thrust of 1090 is that a board member should not make a decision or cast a vote in which they have a financial interest. And typically, as you know, that plays out usually when there is a contract that comes before a governmental board in which a board member holds an interest, a financial interest, or a member of their household has a financial interest or something like that. Whether or not that interest extends beyond a financial interest and actually extends into portions of their duty as an elected official, that remains to be seen. But my personal approach is to always avoid playing too close to the line on these things. And if there is a way to carry out a task, an appropriate legal task directed by the board in a manner that makes it very clear that no lines not only are not being crossed, but are in no danger of being crossed, I think that's always best.
And Mr. Moore, this is Joanne Lopez again. Is it your understanding that you would be, if hired, that you would be representing the entire board or an individual person on the board?
Well, when a board hires special counsel of this nature, the integrity of the board rises and falls with the collective vote. As you know, each board member has authority, but it begins and ends with the power of their vote. The integrity of the board as a whole is a function of the integrity of the individual votes. And so, for instance, if the board needed assistance with a matter in which one board member or two board members, assuming we have a five-member board, in which those one or two are implicated, then representation by any counsel, whether it's me or somebody else, would be for the integrity of the board. And in order to maintain that, it would be requested that any individuals on the board who may be affected or who are standing in the place of affecting the decision would recuse themselves for the period of time that any tasks were completed and any decision was made. Now, of course, after a decision is made and the board renders a decision or directs a path and the matter is concluded, then of course, whomever it is working who may have had to recuse themselves would be brought back in to do everything else that they need to do. But as far as the recusal is concerned, it would also be limited to decision making. That person would not be precluded from performing other tasks that as an elected official they're expected to perform. They just would steer clear of whatever the particular legal issue is because the representation will be for the board in its integrity as a whole.
I have a question, Mr. Moore.
Yes.
In a case where an individual is being accused, am I to understand that they have no voice in who is selected to represent the board as well as themselves?
Well, I think it's important to note in a five-board panel, if that particular ability to vote in an objective fashion is called into question, I don't think there's anything wrong, and I think there's everything right with having that person recuse themselves. The power of the voice of somebody who is participating in any type of task like this really comes out during the course of the investigation, where or whatever the task is, where individuals who are involved have the opportunity to share their thoughts, their feelings, what they've witnessed, what they've read, what they've thought and heard. That would be vetted throughout the course of whatever task is being performed. The limitation on the recusal would be solely for the purpose of employment of the service provider. And there may be other things depending on the nature of the task at hand, where it would be prudent for the individuals involved to not conduct themselves in a manner so as to exacerbate the issue being looked into. I'm sorry to be so circumspect and speak so obliquely, but I'm operating on a dearth of information, and so I'm trying to give you everything I can with what little I have. It's difficult to spin gold from straw, but go ahead.
I have another question for Mr. Moore. Would your responsibilities under this contract include ensuring the district provide an environment free from harassment and discrimination in accordance with Board Policy 4030 and state and federal law?
Well, assuming the board policy that you quoted comports with California and federal law, the answer would always be yes. The reality is that any school board which employs counsel gets two responsibilities for the price of one with any attorney. Obviously, there's the attorney-client privilege and the obligations that counsel have to their client. But above and beyond that, and I wouldn't say that it supersedes that responsibility, but it's of a different order, and that is the responsibility of counsel as an officer of the court to do nothing which conflicts with the oath that an attorney takes when they are sworn into office as an attorney. And as you may know, attorneys are officers of the court. So I and other attorneys have even a higher obligation than they do simply to the client. For instance, if I have a client, and thankfully I've been able to vet my clients to the point where I've never been asked to do this. But if I had a client that asked me to do something that was slightly underhanded, or that used sleight of hand, or was overly artful to lead the court or someone else to a conclusion that wasn't factually correct, I would decline to do so. And if I couldn't prevail upon him, I would simply decline to represent him any further. So with regard to the school districts that I currently represent, my advice to them always is to comply with the law. And to the extent they haven't been, to amend immediately and to begin do so. So I hope that my question didn't beg the question, but Ms. Lopez, does that answer your question?
That was my question. Yes, thank you.
Okay. At this point, I am closing discussion. I think we can talk this through forever. We just simply need to take a vote. So I will put the motion back on the table. And the motion that was made by Mr. Favela and seconded by myself was to approve the firm of Mundell, Odlum, and Haas for legal services for the board.
Well, we have to address the motion that's on the table, which is the second motion.
The second motion was,
Mrs. Lieber recused herself for conflict of interest.
You're correct procedurally. Thank you, Mrs. Lopez. I call for that vote.
Can you please restate the motion that's on the table?
Mrs. Lopez, would you like to restate your motion?
Yes, I would respectfully ask that Mrs. Lieber leave the meeting, this meeting and the closed session meeting, and recuse herself to avoid any issues or appearance of conflict of interest in the hiring of an attorney.
Yes, and do we have a second?
I will second.
All right, let's call the vote. Mrs. Leibs?
Aye.
Mrs. Lopez?
Aye.
Mrs. Lieber?
No.
Mr. Favela?
Mr. Favela, you're on mute.
Mr. Favela, a yes vote requires Mrs. Lieber to recuse herself. A no vote requires her to remain on the vote, just to restate the motion, if I restated correctly. We have an aye vote for Mrs. Lopez, all right, a no vote. Mrs. Lundeen votes no as well. The motion fails. Mr. Favela, would you like to restate your motion for approving the contract of this legal counsel? The motion that we tabled. Or would you like me to just, I can just repeat it and then you can tell me if that's what you.
Yes, please repeat it. Yeah.
Okay, so the motion is approval of the contract for the legal services of Mundell, Odlum, and Hawes for legal services for the board.
Are we supposed to do that in closed session? I'm trying to, were we
Say it
supposed
again.
were we supposed to do that in closed session?
We need to do it in open session. All contracts, all financial arrangements need to be made in open session. And so that's why we are in open session, calling for the approval of the contract with the firm of Mundell, Odlum, and Hawes for legal services for the board regarding pending litigation.
Yes, I call for the board to approve the services of Moore for pending litigation.
All right, we have the motion. I will second that motion. I call for the vote.
Wait, I have some questions related to Mr. Moore.
I think you've asked those questions.
I have many more questions, and I
Yeah.
have every right to ask all the questions until I feel comfortable making an informed decision.
Go right ahead. Mr. Moore,
you.
you have some questions. Mrs. Lopez, would you please proceed?
Thank you. Mr. Moore, in the contract that we were shared with today, there was some information about your fees. So my question is, are these the normal fees that you charge for every case that you take on?
Not every case. Quite honestly, we charge a different fee schedule for our public work. We charge a different rate for very complex matters in our civil arena. We're very mindful that school districts and other educational nonprofits and charter schools, they have budgets to work with. And we try to keep our fees in that regard well within the lines, both upper and lower of practitioners in that industry.
Okay, and then do you have any idea how many hours you anticipate that working with the board will require?
I don't. It depends on the nature of the matter that I'm asked to handle. My goal generally is to never keep things going, but to find the quickest, most effective, appropriate off-ramp so that boards and districts can get on with the business for which they were elected, which is to support the children. So I think if I were just going to shoot from the hip, and I ask that you not hold it to me, I would say probably between 10 and 15 hours, assuming, of course, that the matter is fairly narrow. And so I think it would be within that realm. I don't think that's an unreasonable. It could be a little less. It could be a little more, although I don't anticipate it will be more, at least in the short term, because as I understand it, the issue before the board for which I would be engaged or anyone else would be engaged is fairly narrow, as I understand it.
So is it your understanding that whoever the board hires was going to be part of the complaint investigation process?
You know, I haven't really discussed it with anyone to that level of specificity. I don't know if there, for instance, maybe other firms for whom additional or further work would be done. I know that the very short conversations I had revolved around this narrow issue, and again, for which I don't have a lot of detail, but I understood that it was a fairly narrow matter, and any counsel hired by the board focuses upon the matters that the board determines, and those can be narrow or those can be broad, depending on what the will of the board is.
And did anybody on the board indicate to you that they had authority to make decisions on the hiring process?
No, and in my experience, as I said a little bit earlier, the will and the authority of the board is a collective authority, and looking out over the course of my career, And my other clients, I don't think I've heard that from any board member that, you know, don't worry, Mr. Moore, I can make X, Y, or Z happen. That would be a very uncomfortable conversation to have. I haven't had that, certainly not with anyone on this board, but frankly, not with my other clients as well.
Okay. And then my last question for you is just, oh, I lost my train of thought. I'll come back to it in just a second. I would like to ask a question of a couple of the board members before we move forward. And that is, oh, I know what the question was for you, Mr. Moore. When you were contacted by any board member, what was it that they indicated to you we needed to have? What were the services they asked you for?
I was made aware that there may be a need for an investigation with regard to a pending complaint. Okay. But I don't have more information than that. I don't have any documents. I don't know who who the players are. I'm not clear on that. Again, they were very cursory conversations that revolved around my availability and the fitness of my experience.
Thank you.
I have a question for Mrs. Lieber. Who directed you to Mr. Moore? How did his contact come to your attention?
From the County Board of Education.
Was there someone there specifically?
No, not somebody specific.
So you asked them for referrals?
Mm-hmm. Just like I got the referral of Jim Hugh.
And was it your understanding that Mr. Moore would be representing you or the district?
Oh, by the way, the district. Oh, by the way, I also got recommendations from the California School Board Association because they also gave me 3 names to reach out to, for the board to consider. So actually there's 2 locations that gave us, once we had the vote on Saturday, then I reached out to the California School Board Association and to the County Board of Education. I'm sorry, what was your second question?
Just a comment that, it sounds like you did go through a process. I would have appreciated, since this is a decision that is supposed to be made by the entire board, that we all would have been privy to the same information as far as who was looked at for this contract, their rates, for transparency, because we've had very little information in this process. And, so, we have a policy of all board members receiving the same information. In this case, that has obviously not occurred.
Thank you. I'll try to get better at this. I've only been board president for 14 days, not including the Christmas holiday. So I'm not saying that I couldn't do a better job. And just like President Biden said, this democracy and this board, our goal is to get better and better at what we do. So I appreciate your criticism. I've noted your criticism and I'll try to get better at it. I do want to say though that, I worked over the holiday and I didn't, and you only want to drag your poor board in when you have to. So I'm sorry, but I apologize and hope there'll be a better president for you in the future.
Thank you.
Any other questions, discussion items? Okay, thank you. I will call for the vote. I'm going to look at my screen. Mrs. Lopez?
No.
Mrs. Leibs?
No.
Mrs. Lieber?
Yes.
Mr. Favela?
Yes.
Mrs. Lundeen? Yes. The motion passes. With that, I will turn running over the meeting back to the president of the board. Thank you.
Okay, thank you very much. I'm going to close the open session, and there is another sign in for the closed session, which will follow immediately. So I believe we have to actually close out of this session, and then we'll have to come back into open session at the end. So we'll be closing out. We'll be all signing into another. Do all of you receive from Mrs. Weaver the link to sign into the closed session?
Yes.
Yes.
Okay, thank you. So I don't want to abandon you without that. So I'm gonna close this out of this meeting, and we'll be reconvening in closed session. Thank you.
Thank you. The meeting. So we have completed our closed session. No action was taken during closed section that is reportable. We can turn the meeting back to you, Mrs. Lieber, for the special meeting. Thank you.
Okay, so I'm reopening the special meeting, and since we don't have anything to report out, I believe we will be closing without a report at 6:01, unless there's any comments that would like to be shared before we close the meeting. No comments? Okay,
I think
well
we're-
then, the meeting is adjourned at 6:02.
Thank you, everyone.
All right. Good night, everybody.
Good night.
Good night.